Welcome to the deep dive. Today, we're tackling something really significant happening right now, the way artificial intelligence is moving into the European intellectual property world.
Yeah,
Fast.
it really is accelerating.
Yeah, and we've been looking at some great material from alphalist.ai. They're focused specifically on AI for IP professionals.
Good stuff. Very insightful.
So our mission for this deep dive is basically to get our heads around how AI is actually changing things for IP pros in Europe. The good stuff, the efficiencies, but also, and this is crucial, the serious points we need to consider,
Yeah.
especially confidentiality. That's huge.
Absolutely fundamental in IP. Okay, so where do we start? Maybe the EPO, the European Patent Office.
Good idea. They seem to be pretty far along, right?
Oh, definitely. Early adopters, they have this system, EP Autoclay. It automatically assigns those CPC codes to patent applications.
Ah, the classification codes. That must be a big help.
Huge. Think about it. AI reads the tech description and sorts it. That used to take a lot of human examiner time, Speeds things up and makes it more consistent, too.
Right, consistency across thousands of applications. I can see that. And it's not just sorting, is it? They're using AI for searching, too, prior art searches.
Exactly. Really sophisticated stuff. AI search tech using semantic similarity, understanding the meaning, not just matching words, and vector space searches.
Okay, so smarter searching, how does that actually help?
Well, it finds conceptually similar inventions, even if
Yeah.
they use different terms. Big help for examiners trying to find relevant prior art, but also great for applicants doing their own searches beforehand. They can find potential issues earlier.
So better searching up front saves trouble later. Makes sense. And I heard about something called LIP, the Legal Information Platform.
Yes, LIP, that's a generative AI legal assistant. Basically, you can ask it questions in normal language, and it searches through EPO legal resources to find answers.
Wow. Like having an AI research assistant who knows EPO rules.
Pretty much. It makes accessing that complex legal information much, much easier. Democratizes it in a way.
That's powerful. And they're even testing AI for things like taking minutes in oral proceedings.
Yeah, pilot projects. It shows they see AI as like a partner, augmenting the human experts, not replacing them. It's all part of their strategic plan for 2028.
Interesting. Okay, so the EPO is really integrating AI. What about the UIPO, the Trademark and Designs Office? Similar trends there.
Very similar. They're also using AI to shake things up in trademark and design examination. They've got an AI classification assistant, too.
For goods and services descriptions.
Exactly. Helps applicants get those right the first time. You know how tricky those can be. Getting them wrong causes delays, rejections sometimes. This AI smooths that out.
Yeah, I can imagine. Little details that make a big difference. And what about searching images? Trademarks and designs are visual.
Right. So they have AI-powered image recognition built into TM View and Design View. Makes searching for visually similar marks or designs way easier.
Like a reverse image search for IP?
Kind of, yeah, but trained specifically on millions of trademarks and designs. It helps examiners spot conflicts, but also helps businesses and lawyers check for similar designs before they file. Proactive risk management.
That could save a lot of headaches and legal fees down the line. Finding potential clashes early. Smart. Any other AI uses at UAPO?
Yeah, they're using AI for decision support. It analyzes past decisions to flag potential issues or precedents for examiners and applicants. Makes the whole process a bit more predictable.
Fewer surprises. Always good. And they have a roadmap, too, like the EPO.
They do, the AI Roadmap 2025. They're planning things like automated formality checks, AI chatbots for support, even AI helping draft decisions. They're clearly committed.
So both big EU IP offices are heavily invested. Now, what about the new player, the Unified Patent Court, the UPC?
Ah, the UPC. Well, they're still pretty new, relatively speaking. Their main focus right now is just getting their digital case management system really stable and running smoothly. Foundation first.
Makes sense. Build the house before you install the smart home tech.
Exactly. But they're perfectly set up for AI later.
Yeah.
Especially with all the different languages involved. Machine translation seems like a no-brainer, right? Using tech the EPO and EU already developed.
Definitely. That would be incredibly useful across all those countries. And maybe down the line, for research, as they build up case law.
Precisely. Once they have a body of decisions, AI could help with legal research, finding relevant precedents, ensuring consistency. They seem open to digital tools, so AI adoption feels likely once they're fully established.
Okay, so the institutions are moving. What about the law firms, the patent attorneys out in private practice? Are they using this stuff?
Oh, absolutely. European patent firms are jumping on board pretty quickly. They see the efficiency gains, the potential for better client service.
So what kind of tools are they using?
Things like AI-powered semantic search engines,
Hmm.
PatSnap, IPRally, tools like that for prior art searches, freedom to operate analysis. They can sift through huge amounts of data much faster.
Right, cutting down that search time and drafting. Is AI helping write patent applications?
It's starting to show real potential there. Generative AI can help draft initial versions, responses during prosecution. It speeds things up.
Freeing up the attorneys for more strategic work.
Exactly. More time for the high-level thinking, the complex analysis,
Yeah.
client advice, not just the drafting grind.
And admin stuff too, I bet. Docketing, data entry.
For sure. AI and docketing systems, pulling data from documents automatically,
Yeah.
even chatbots for initial client contact. But, and this is a big, but they're adopting it cautiously.
Because of confidentiality.
Precisely. They know their ethical obligations.
Hmm.
Which brings us to the European Patent Institute, the EPI. They've issued specific guidelines on using generative AI.
Okay, what do the EPI guidelines say?
They really hammer home the basics. Professional independence, absolute confidentiality, client integrity, and crucially, they say attorneys must use their own judgment. You can't just blindly trust what the AI spits out.
Makes sense. The human expert is still in charge. And what about the data security part?
That's where guidelines 2A and 2B come in. They're really important. Guideline 2A says you must ensure confidentiality for training data, prompts anything you feed the AI. And if there's any reasonable doubt about that
I'll
confidentiality,
use it.
don't use it. Simple as that. Guideline 2B adds that attorneys have a duty to actively figure out the risks. How could information leak? What does the AI provider do with your data? You need to know.
So the burden is entirely on the professional to check the stuff out. You can't just assume it's safe.
Exactly. No assumptions allowed. Which leads us right into the main issue with using many common AI tools, especially those big cloud-based large language models.
Right. Things like ChatGPT, Copilot, Gemini. They're powerful, seem useful, but are they safe for, super sensitive IP work?
That's the million-dollar question, isn't it? The providers might talk about security, but legally, they aren't bound by a lawyer's duty of confidentiality.
Yeah.
If there's a breach, the lawyer's responsible, period.
Wow. Okay. So their terms of service don't protect the lawyer.
Not in terms of professional secrecy obligations, no. So uploading client secrets to a third-party cloud, that could be seen as a breach of duty right there, even if you try to anonymize prompts or whatever.
Why isn't anonymizing enough?
Because most of these LLMs keep your inputs and outputs. They often say in their terms they can use it to improve the model. The data might stick around, you don't really have control.
And we've actually seen leaks happen, right?
Unfortunately, yes. Remember the ChatGPT data exposure incident? Or Samsung employees leaking confidential data by using it. It shows vulnerabilities exist. Bugs, human error, stuff happens.
And from a European standpoint, there are legal hurdles too. GDPR.
Big time. GDPR is very strict about personal data.
Mhm.
Italy fined OpenAI over GDPR issues, remember. The European Data Protection Board is clear. AI using personal data needs GDPR compliance, and claims of anonymization need independent proof.
And it's not just GDPR. Bar rules matter too.
Definitely. National bars, like Germany's, have warned that using cloud LLMs for client data without rock-solid guarantees can violate professional secrecy rules. The CCBE, the Council of Bars and Law Societies of Europe, they agree. Professional secrecy isn't negotiable for convenience.
So the message from regulators and legal bodies is be extremely careful, or just don't do it.
Pretty much. Extreme caution is the minimum. And because of that, we're seeing firms actually banning the use of these general cloud AI tools for client work.
Right, they're creating internal policy saying no.
Exactly. The risk is just seen as too high compared to the benefit, especially when you're dealing with core ethical duties.
So are there alternatives? AI designed for lawyers with confidentiality built in?
Yes, that's where platforms like alphalake.ai come in. They're designed specifically for legal and IP work, with confidentiality and user control as the absolute foundation. The idea is your data stays yours, stays secure, isn't used to train models for others.
So it's about picking the right tool for the job. One built for legal standards, not a general tool you hope is okay.
Precisely. Relying on cloud LLMs you don't control is inherently risky. The lawyer holds the bag if data gets exposed. And providers like OpenAI even tell you not to share sensitive info. They say conversations are reviewed, can't be deleted on request.
That's pretty explicit.
It is. The UK's Cybersecurity Center warns that providers see your queries and probably use them. Many reserve the right to use your content indefinitely.
And exposure isn't just leaks. The AI could output something sensitive later. or the provider could mishandle data internally.
Exactly right. Huge potential legal and financial fallout, reputational damage, plus potential GDPR violations just from how they train the models. And for lawyers, there's the risk of accidentally waiving attorney-client privilege.
How so?
By disclosing privileged info to a platform like OpenAI that isn't bound by attorney confidentiality rules.
Yeah.
And think about trade secrets. Put that into a public LLM and poof, your trade secret protection could be gone.
It really is a minefield. So those EPI guidelines 2A and 2B, they're the key then. If in doubt, don't use it.
That's the core message. You must ensure confidentiality. You have a duty to know what happens to your data. If a tool isn't transparent or can't guarantee confidentiality, avoid it. General cloud services usually fail this test because the data leaves your control, not be logged, analyzed, reused.
So for a cloud-based AI tool to be potentially okay under EPI rules, what would it need?
You'd need, well, incredibly strong, verifiable guarantees, transparent, binding promises on data handling and storage, data staying in the EU or an equivalent safe zone, which rules out the US for many LLMs, really robust security, and absolute verifiable exclusion from any training data pipelines.
That sounds like a very high bar.
It is. And without all that, clearly met and auditable, you have to assume it's unsuitable for confidential work. It's back to, if in doubt, don't use it.
It all comes back to those core principles: attorney-client privilege, professional secrecy, GDPR. Using standard cloud LLMs without verifying confidentiality puts all that at risk.
Absolutely. Think about drafting sensitive patent claims, mapping out litigation strategy, an in-house team using an LLM API and proprietary tech data. All risky if you don't have confidentiality nailed down.
So the answer is purpose-built tools.
It seems to be the safest route. Tools designed for confidentiality, secured infrastructure, models may be fine-tuned for IP, clear privacy policies, and always, always human oversight.
Okay, so wrapping up our deep dive today, it's clear AI has massive potential in European IP. The efficiency, innovation, it's all there for institutions and law firms. But
That confidentiality piece is absolutely non-negotiable. Using AI tools demands really careful thought about data control, model management, and all the legal and ethical angles. It cannot be an afterthought.
couldn't agree more. The benefits are tempting, but the risks if you get confidentiality wrong are just too high.
Exactly. Which leaves us, and you listening, with a big question, really. As AI keeps getting smarter and more integrated, how do our legal and ethical rules around data privacy and IP need to evolve? How do we balance innovation with protecting that core confidentiality?
Good question.
And maybe more immediately, what specific questions should you be asking right now about the AI tools you're considering or maybe already using in your own work? That's something everyone in the IP field needs to be thinking about very carefully.